Well, good evening, everyone, ladies and gentlemen. My name is Andrew Brown, and welcome to our evening to discuss restructuring plans and whether it's time to reconsider them. It is the summer solstice, and I'm glad to see you've all come here to celebrate rather than do anything more fun. Joining me today on the panel is an absolute murderer's row of individuals who have been involved in the two recent cases involving HMRC. To my right, to introduce the individuals, we have Stephen Cottee, partner at Pinsent Masons, who leads the restructuring team, fresh off winning the restructuring team of the year, I believe last night at the Lawyer Awards. He looks fresher than I would be in such circumstances, so well done. Stephen led the legal team for the Nasmyth Group Restructuring Plan, which was heard in April. So will give us a bit of experience about that firsthand. He also advises private equity funds, debt funds, banks, and office holders in the UK and internationally, as well as dealing with the restructure of the Nasmyth Group. He has most recently acted on the administrations of Derby County Football Club, Paperchase, and the Ince Group. I think Ince owes me some money, so I'll send my clerks around a little later if possible.
Just to show I don't lose every case, so there's a bit of balance there, other than Nasmyth.
Well, fantastic. We also have Andrew Dalton, partner at Begbie's Trainer. For any American football fans out there, he's not the quarterback of the Carolina Panthers. That's a different Andrew. He's a partner in the London office of Begbie's, at which he describes he's been there for forever, I believe. And he specializes in advisory and contingency planning, CVIs, and restructuring plans. He led the team in the House restructuring plan, which actually succeeded in cramming down HMRC. And was heavily involved in the Nasmyth restructuring plan as well. So we've got quite a bit of expertise on that case to my right. And to my left, we have at the far end, Hayley Çapani, legal director at Shoosmiths. She co-leads the insolvency and restructuring team there. She has been heavily involved in both schemes of arrangements, I think the Sunbird case, as well as restructuring plans. She was also the lead of the legal team, for Great Annual Savings that we're speaking about tonight. And I believe is involved in the Fitness First restructuring plan as well for the secured creditor. So she brings a wealth of experience. She's also an expert, I have to say, from my own personal experience in cryptocurrency. I lean on her for all knowledge of such things. And then directly to my left, least of us, is Matt Weaver, King's Counsel. Matt is an insolvency barrister who specializes in all elements of insolvency, but in particular restructuring matters. You might remember from such past hits as the New Look CVA, the Regis matter, where he was successful, and the Croxon and Utility Point versus Ofgem case, where he was kind of successful, kind of not, but looked good doing it. He was counsel for Great Annual Savings in May of this year, so to my left we have quite a lot of experience in that matter. Now, with that being said, that's our panel for tonight. I'm going to hand over for Stephen to give us the brief details of the Nasmyth case.
Still getting over it, really. It's a therapy session being here, really, to deal with Nasmyth. And Andrew, you dealt with Nasmyth as well in a first-hand experience. It was sort of in the upper end of the mid-market, really, wasn't it? Employees, 60 million turnover. It was a topco restructuring plan. And I think, Andrew, we felt that was a bit different. It wasn't a trading business. There were, I think, 12 to 13 subsids below the topco. And we had a small amount of HMRC debt with very few employees, not many trade creditors. The business needed new monies. The value broke in the R Capital debt. It was owned by R Capital. They had 80% of the equity in a £7.5 million debt facility. Secured Trust Andy were in there as well as senior secured creditors fully covered. So the business needed new monies. Value broke with R Capital. The problem we had was that the former manager had a £9 million claim against Nasmyth Group for wrongful dismissal. So R Capital didn't really want to put new money in when they've got this £9 million claim. It was felt a way to achieve a clean break with former management, deal with that claim and introduce new monies via a restructuring plan was better than a pre-pack administration. Under the plan, we were going to cram down HMRC. They're only owed £400,000. We didn't think that would be controversial. We were going to cram down former management, and as part of the new loan, 100% of the equity would go across to R Capital as they were putting new money in, putting risk money in. There was a 10% pot for HMRC and a 10% pot for unsecureds. I think, Andy, with the new money and the way it was structured, and HMRC were firmly out of the money, because the relevant alternative was an admin topco share sale, so there were no floating charge realisations. I think we were pretty confident that the court would sanction this plan. However, we were greatly misplaced with that confidence. We felt there was clear evidence that administration was the relevant alternative. New monies was going in. Our capital were an in-the-money creditor, so we felt it was right that they should have the restructuring surplus and not out-of-the-money creditors. However, the court refused the plan on discretionary grounds on the basis that the time to pay for the subsidiary companies below the company itself proposing the plan was still being discussed with HMRC. They had not been agreed, and the court felt that was a roadblock for the restructuring plan. Now, that's the first time we've heard of this concept of a roadblock. We'd heard of a blot on the plan, and we didn't feel there was a blot on the plan, but the judge, Mr. Justice Leach, felt there was a roadblock for the restructuring plan, and that's why he didn't sanction the plan. We felt we could have appealed that decision. However, our capital had full debenture security over the topco and the trading subsidiaries. So 1 hour after the judgment was handed down, a notice of intention was filed, and 1 week later there was a pre-pack administration sale that was completed back to an R capital controlled entity. So the end result for HMRC was that they got nothing. For former management, they got nothing. And we felt it was somewhat of a Pyrrhic victory for HMRC that we ended up with an administration when we had a private equity turnaround investor who was very keen to try this new restructuring plan process, this new debtor in possession process that we've been selling in the market as an alternative to insolvency. But we found that the court's reluctance, I think, to back private equity, the optics of private equity holding the debt, holding the equity, and HMRC there getting crammed down when they are a preferential status was something that didn't sit easily with the judge, which is why he's created almost a special status for HMRC, feels they're an involuntary creditor, feels that we should treat them differently. He says you can cram down HMRC, but you've got to be very careful. And we feel, as we'll discuss later on, it has brought into question how viable restructuring plans are now in the mid-market, unfortunately. So it was a bruising experience. We felt we had a pretty good plan that wasn't particularly controversial, without a large amount of revenue debt, with new monies coming in, and it was right for the business and would take the company forward. However, we got caught out with a discretionary decision about time to pay arrangements with subsidiaries that were separate from the topco where the plan was proposed. So I think we're feeling slightly sore about it, and turnaround investors like our capital are now questioning, are they better going the pre-pack route, which they know and get certainty of outcome, or do they go to court with a judge who may not be experienced in insolvency matters and get an unpredictable decision? So it's made it difficult, I think.
Well, a joyous time then.
Exactly.
HMRC really being the boogeyman there. I wonder, before we move on to actually discussing the substance of that, perhaps we should get the facts of Great Annual Savings, GAS, I think for short, from Hayley.
Pretty attractive acronym, GAS. I should probably start by correcting something you said. Whilst I would love to co-lead the entire Shoosmiths restructuring practice, I do not. It's just the insolvency litigation bit, so I will get shot if I took that. But so GAS itself, just as a, and I will keep this brief because the other things we're going to talk about is way more interesting. So why was the company in trouble? Well, the company was an energy broker, so it sourced energy contracts for customers, business to business, no consumers, and then it got commissions back for the contracts that it sourced. So some of these commissions were paid up front, and for quite a few issues that are going on in the market, unsurprisingly in the sort of energy industry, so not only COVID, which I think was the only thing that was really mentioned in the hearing, but the war in Ukraine, which was a little bit more important for them, and the tanking gas prices, the trust administration, a lot of these upfront commissions that had been paid were woefully over the actual usage, and so there were a lot of clawback claims. So these clawback claims are really hitting the balance sheet, causing a great problem for the company going forward. And so that was one of the main cruxes of why something needed to be done. HMRC, there was a chunky debt, shall we say. I sort of smirk at Steve's 450, was it? Or where I think by the time of sanction hearing, we had 9 million. So it was a slightly bigger figure. And HMRC had already issued a winding up petition. So we were going through the plan at the same time as adjourning every hearing that came up for the winder. So there was this sort of added edge of, are we going to get the adjournment through? Of course, you're like, oh yeah, it should be fine. But on the inside, you're turning up in the winders like, please go through. The plan itself, I think one of the important things, no new money, and this comes out in the judgment. So the company was intending to trade its way out of its problems, but trying to deal with the issues first. And in terms of what was going to happen, there were 4 in-the-money creditors, secure creditor who was doing a substantial debt for equity swap, write-off of interest, and one of the loans was being converted into a term loan. HMRC was in the money, which I think is unique for one of these cases. And for the small sum of 9 million, it was going to get back 600k over 2 years. And then the head office landlord and the rating authority landlord that attached to the head office. So they were all of our in-the-money creditors. Out the money creditors, there were connected parties, critical creditors, and then the energy suppliers and other critical creditors were in categories, much like you'd get with a CVA, so category 1, category 2, category 3, all treated in slightly different ways, but our pence in the pound dividend for their debt is essentially what they were going to get on a sliding scale. How did the creditors vote? Well, we had 15 classes in the end, so no small feat. And actually 12 of the meetings voted 100% in favour. HMRC, unsurprisingly, against, as did the lowest of our energy categories, category 3 energy. And one group abstained, and I think that was indifference more than anything else. So working through all of that, we're thinking, 12 out of 15, that's quite a good, I daren't say, what is it, wind behind a...
Fair wind.
Thank you, fair wind, I'm going to get the wrong acronym. But nevertheless, the court refused to sanction. 2 reasons predominantly. One, that the company did not satisfy on the balance of probabilities that HMRC would be no worse off under the plan than in the relevant alternative. I will stress HMRC only. The company did satisfy the balance of probabilities for the other creditors. So it is just HMRC's, and the margin of difference is basically where we came down to and had a real fight in the hearing. And then allocation of the restructuring surplus. So was it fair? And that, I think, is still going to be an open question and still fought over at the moment. So they were the 2 reasons that the plan didn't go through. What happened next? Well, the winder hearing was the day after, judgment handed down. So judgment handed down at 2 p.m. By 4 p.m, the company was in admin. So it was very sad for the company, but the company is now in admin. Slightly bruising, and a real shame, I think, particularly bruising on our experts, because HMRC didn't file any evidence in opposition, and so for their evidence to have not satisfied the court in absence of anything to the contrary is pretty harsh, if I'm totally honest. And that's not just speaking because I feel like I need to defend everyone.
So, thanks for that summary. What appears from both these cases is HMRC was really getting involved, sticking the oar in and really messing things up, I would say. Andrew, perhaps you can tell us from your perspective, what do you think of HMRC and what the impact of their involvement will be?
Keep it clean, Andrew.
We're amongst friends.
Strap in, yeah. No, I think certainly the main point really from our perspective is the lack of guidance. And that goes to certainty when you're talking to clients as an advisor. How can you give them certainty of an outcome if you've got no sort of playbook to go by from HMRC's perspective? So that's not been massively helpful. I think we also had issues generally in terms of engagement. Obviously, Steve mentioned there the time to pay in the subsidiaries was a big point, and actually ended up sort of being the hook that you hang on to put the plan away. And we'd been trying for some time to agree that time to pay in the subsidiaries. And it was only 1 week before the sanction hearing that they came back and said no. And I don't think that was anything untoward going on there. It wasn't a strategy, I don't think. I think it was just a case of under-resourced, not necessarily having the team available to be able to consider these things. And I think really what would be helpful is if there was an element of guidance coming from HMRC, although I don't expect that to come anytime soon. I mean, what we are seeing in the market now, I think, is, as it's developing, is others take other approaches. I think Fitness First are going for, and you'll just stop me if I'm wrong, but I think Fitness First are going for almost like a time-to-pay type arrangement and kind of, you know, moving HMRC down the road. But the issue
is over 5 months, isn't it? They
yeah,
pay
it's a
them
very
in full,
short,
but over 5 months, over a
yeah.
short period. So it's whether with plans you propose a time to pay to get the HMRC support.
and then you don't have that to worry about. But I think that's not going to be a one-size-fits-all approach, because a lot of businesses are going to have those HMRC arrears that they can't service. So I think it's tricky. I
think, Andrew, we were talking earlier, you said even during your hearing, when the judge asked HMRC, is there a policy to vote against all plans? And if not, why have you voted against this plan? I think we were discussing earlier, you said they really didn't have an answer for that.
No, they didn't. And there were general points put forward, I think the same with gas, about potential antecedent transactions. But there was no detail behind that, and nothing specifically pleaded. So it was a question that the judge, to be fair to him, kept coming back to again and again. You know, why this plan? Why don't you like this plan? And they couldn't really get there, I don't think. I don't know if you...
It wasn't that old, the debt, was it? They couldn't say, well,
No.
the debt was very old or it had built up
And we
to
kept them
certain
current on
levels.
the way through. So we proposed the plan in the PSL went out in December. And we made sure that there was no deterioration in the revenues position between then and the sanction hearing. So, yeah, we were trying to keep our noses clean on all that stuff, but it didn't seem to land.
Well, we've certainly heard about HMRC in that case, but what about any positives from the case? Matt, do you have any positives?
There are positives, notwithstanding that we are fairly battered. I mean, I think the judgments are helpful to some extent in clarifying issues that had been rumbling on in the past. So, for instance, in the convening hearing in gas, one of the issues that rose its head was, can you, in a plan, compromise creditors by simply asking them to give away their rights, to surrender their rights? So, in the plan as it was initially drafted, contingent creditors in gas were just going to be paid off for £1 because their claims were impossible to value at any higher than that. Mr Justice Trower raised the issue that had been flagged up in some previous decisions, which is a scheme decisions which say you can't do a compromise with a creditor if all they're doing is surrendering their rights. There has to be some give and take. But actually, although we quite craftily amended our plan so that we were giving them a pot of money to dip into rather than simply giving them £1, Trower did give a judgment, albeit obiter, which said he can't actually see a problem with creditors surrendering. Essentially, his logic was, if they're going to get nothing in the relevant alternative, why does it matter that they're giving away their rights in the plan? They ought to be perfectly entitled to do that. So I think there is some clarity in that you could have some differentiation between schemes and plans where creditors could simply give away their rights in these sorts of instances. You also had, in the sanction hearings, you had Adam Johnson Jay's approach to antecedent transactions, because in our case, HMRC made a big deal about potential antecedent transactions, and they went through all the conduct of the directors, criticising it from here to there and saying that there were prima facie strong claims for wrongful trading, preference payments and the like. And they were able to quantify them, they said, in terms of ballpark figures. Adam Johnson's judgment is helpful in that he says, look, there may well be prima facie claims, but we all know that prima facie claims, when you dig into them, can turn into a pile of rubble. And in the circumstances of a sanction hearing, he accepted our submissions that Sir Alistair Norris in Amicus had got it right by saying sanction hearing isn't the venue to litigate potential antecedent transactions. That's not what the court's there for. But in any event, how on earth would you value them, which is a point Adam Johnson came back to. And he said, look, I simply can't give them any merit because I had no idea what recoverability you might get out of them. And that's not the venue to discuss then. So that's helpful in terms of, if you're a company, those sorts of arguments may be easier to deal with. Similarly, Adam Johnson's approach to out-of-the-money creditors, and I pause here because we'll discuss it later, it is a different approach to Mr Justice Leach's approach to out-of-money creditors, which provides practitioners with an interesting conundrum. But Adam Johnson was quite clear that we had creditors that were turning up and wanted to oppose, but they were significantly out of the money. And his view very clearly was, as much as it's lovely to have people in court, I don't need to give any heed to the views of out-of-the-money creditors, because fundamentally a restructuring plan is all about those creditors that are in the money dividing up the restructuring surplus between them. And if out-of-money creditors are dissatisfied, so be it, because they're no worse off than under the relevant alternative. So again, helpful in terms of our experiences, where certainly we had 3 different out-of-the-money creditors turn up to the sanction hearing to try and cause mischief. I think Steve and Andrew had a number of others, including
we had a number
in person.
over the 3-day sanction hearing. It just increases cost, doesn't it, which is difficult in the mid-market.
And he gave a lot of time to them as well. There wasn't, I don't think it was the same approach as in gas. There was they got a big platform to get up and have a go, and it was very clear they were out the money. The valuation evidence said that, and nobody challenged that, and it was acknowledged that that was the case. So it was slightly odd for them to have such a long platform, as it were. So.
And HMRC were out of the money, but he did say they would have an interest and their views should be taken into account. And we didn't feel, as they were out of the money, that they would be able to articulate a view on the restructuring surplus or have any of the restructuring surplus. Yeah. So without that certainty of outcome, it makes it difficult for private equity clients to go to court feeling they're in the money and they can divide the restructuring surplus up amongst themselves.
Yeah, I mean, the final point that was a positive was in both decisions. I think HMRC in both cases had, perhaps surprisingly, submitted that tax monies are held on trust for HMRC. In our hearing, it was that they were held on trust. What, a real trust? Well, no, not quite a real trust. So what, a quasi-trust? Well, yes, sort of like a quasi-trust, but you just can't pay away HMRC monies. And ultimately, both judges came to what I think is absolutely the right decision, which is taxes are not held on trust for HMRC. That's a fallacy from years ago that we've gone way beyond. And therefore, there's nothing special about the money that you're holding that is due to HMRC as opposed to money that you're holding that might be due to other creditors. So that, to the extent that that pulls an arrow out of HMRC's quiver for any future cases, that's helpful for companies.
Andy did say you can cram down HMRC, Leach, didn't he? But there has to be good reason. So he left the door open, but it's not quite clear what the good reason is, how much you leave in the pot for them, or what you propose really out of the restructuring surplus for them.
Yeah, and that's where then you get, so move away from the positives for a moment and look at the potential issues. They're not necessarily negatives, but they are potential issues that companies have got to deal with. And that's front and centre, isn't it? Because Adam Johnson said, yes, you can cram down HMRC, you've just got to be able to explain why, and it's got to be fair. Whereas my reading of Mr. Justice Leach's judgment is slightly different. He says, yes, you can cram them down, but you have to use caution because it's HMRC. Which
he sort of gave them special status, I think, to agree that it's Crown monies and trading with Crown monies was serious and those monies should be used for the public purse. And I don't think he liked the concept of directors trading with Crown monies or HMRC being left behind, but they would be left behind on a pre-pack administration when it was a fixed charge asset. He didn't understand that a pre-pack would leave them behind, the same as the restructuring plan did. He didn't like it conceptually and sort of inferred they've got some special status that you do need to take into account when you put forward the plan.
And that was very different to what Zaccaroli found on House, where it was, they don't have any special status. If they wanted to have special status, then that would have been written into the Act, and it wasn't. So.
I think in the mid-market, though, one of the problem is with HMRC, if they're not engaging. And so on gas, we sent out our PSL, called HMRC, said, this is on the way, let's have a chat, we'd really like to talk to you, engage with you. We had a Teams call with their team, what is an RP? What are you looking for? That was all in December. It went swimmingly well, everyone was best friends, and then January, I think it flipped into their in-house legal, and that was it. Totally different approach, really aggressive. And then there was no communication. So in the mid-market, when you have got really little sums to play with, how do you know what's a good offer for them? Because what you're giving to them, you're not giving to someone else. We haven't got millions of pounds sloshing around. It's really tiny margins. So how do you know what's a good offer with someone who won't engage? You can't negotiate. You're negotiating against yourself, which is really hard to justify to a client. Oh, yeah, we need to give them that. I know they haven't asked for it, and I know they never will, but we need to give them that anyway. It's really hard to justify.
They've got a CVA team, but not a restructuring plan team. They don't
It's the
seem to
same team.
understand the concept of plans, do they? We just found it difficult to have that dialogue with them, or for them to understand the concept.
Yeah.
And then they just vote against, as their
Our
default
Teams call
position.
didn't help. They still didn't know when they spoke to
Yeah.
you.
Yeah, and I think, so when you combine the difficulty of dealing with HMRC, then look at some of the inconsistencies between the two recent judgments, and it occurred to me that how the two judges dealt with out-of-the-money creditors was radically different. In our case, Adam Johnson took what I thought was the sensible approach, which is to say if you're out of the money, frankly, it doesn't really affect anything. Whereas looking at the Nasmyth judgment, Justice Leach appears to accept that they're out of the money, but still says that they have a proper basis to oppose the scheme and ought to be heard, which is an odd way of approaching
Well, it goes against Virgin Active, doesn't it? And Smile, all the case law that we advise the clients on seem to say if you're out of the money, you're out of the money, you don't get the restructuring surplus, and was consistent on that. And he's rode back from that now, which has made it really difficult to advise clients.
Yeah, and he went even further with HMRC by saying they were out of the money for your company, but because your group companies owed them different liabilities, they had a genuine economic interest in the plan and therefore were entitled to be considered and thought of, which is miles away from how Mr. Justice Adam Johnson interpreted genuine economic interest. He was very clear in our case that the only thing he was looking at, and this was genuine economic interest, but also looking at are you no worse off, was how is your debt treated in the plan, how is it treated in the relevant alternative, full stop. So nothing else mattered. He rejected arguments from us that said future tax revenues might be a relevant consideration. He rejected an argument from one of the other creditors saying that their commercial interests being upset was a relevant consideration. So he's gone very narrow on how do you look at these. Mr. Justice Leach appears to have gone enormously wide by saying, look, I accept HMRC are getting nothing in yours, but because they've got a connected group liability, yeah, absolutely, they've got a genuine economic interest.
It makes it difficult without their consent, doesn't it, doing a plan, unless you've agreed a time to pay with them or proposed to pay them in full over a period. I think it makes it very difficult when you're cramming them down to go to the courts now with that inconsistency.
Yeah. And critical creditors. That's another topic where the judges appear to have completely different views.
He made us work very hard on critical creditors to show they were essential, or that was the right business decision, to go list by list to justify why a creditor was critical. I think he ended up in the right place on that, that they've got to be essential or made for a respectable commercial decision, but there was a lot of cost in justifying every single payment. And the business critical creditors changed, but some would get paid because they were critical over that 5-month period, and we're constantly updating the list and justifying why different creditors were now critical.
I mean, we were debating 1,500 quid for a good 20 minutes, weren't we? I think that.
Yes, you go on a line by line, and it gets disproportionate for the cost in the mid-market to go through every single business critical creditor. And it's very different on CVAs, really, where, it was a far wider definition.
Yeah, and in gas, we were a trading entity, so had a number of critical creditors, as you can imagine. And Adam Johnson's approach was completely different in saying, I'm going to trust management. That's the touchstone, is that if the management consider that these are crucial for business continuing, I'm not going to explore them line by line. So two different judges taking radically different views. And Steve, the bit that struck me from Justice Leach's comments as well was he queried why the company were not treating HMRC as a critical creditor.
Yeah, he felt they should be paid ahead of trade fair creditors, and he couldn't understand why they were paying for a trade fair when we said that was business critical instead of paying HMRC. He didn't understand you need to preserve the business to be able to pay HMRC going forward, and business critical decisions are for the board really to make.
Yeah, and that was a similar issue in us, wasn't it?
Yeah, I was going to say for critical creditors. The amount that you have to, in correspondence. So we were having, when to 12, 14-page letters in 48 hours. And so how can you justify that cost?
There's an interesting question here that I want to raise, which is bringing up the issue of evidence and HMRC's evidence. What was the issue with the expert evidence on this case? Because did HMRC actually put in expert evidence?
No. No, absolutely not. So we had expert evidence on recoverability of book debts within the relevant alternative. That had been gone through by a specialist debt recovery agency. That had been sense checked by the proposed plan administrators. And as everybody that's done any insolvency work will have recognised, it took the book value, and said if this enters into a form of insolvency, you can get rid of that, and actually your recovery is likely to be a fraction of what your book debts are. The judge simply refused to accept that, I think he called it a drastic reduction. He couldn't understand the concept that simply being in an insolvency process affects your ability to recover book debts, which anybody that's done any insolvency work will tell you is a matter of fact. There's necessarily no logic to it, because your contractual rights don't necessarily change, but the reality is you do not recover the sort of sums you do if you continue trading. And he simply refused to accept that where the expert had said, these are the contracts the company tells us are unlikely to be recoverable, his criticism of the experts were, you haven't interrogated that yourself. And the obvious answer to that is, well, what exactly would you expect an expert to do? If the company directors who understand these contractual relationships say they're not paying us, how do you want to review that? How much more information do you go into? Do you need to contact the supplier? Do you need to contact the creditor? None of that really took any attention away from the fact that the judge simply disliked the expert evidence. But as Andrew pointed out and Hayley said, HMRC didn't put in their own evidence. So they simply said, that's wrong because you haven't explained it properly, with no counterfactual scenario. And I think, Steve, in your case, they did something very similar on the relevant alternative, didn't they?
They didn't really put very much evidence in at all, did they, in ours? There was no expert evidence to dispute where the value broke or that they were out of their money. They conceded that in the end, I think.
Yeah, we had some correspondence beforehand about it with the other creditors, not necessarily the revenue, but they certainly didn't dispute it on the day. I think the bit that was disputed more on the day was more around whether it would actually go into administration, wasn't it? Which is
they didn't believe that till we held the court to the gun to the court's head by telling the court an NOI would go down if the plan wasn't sanctioned. So the judge didn't believe that administration was the relevant alternative, and he wanted to call our capital's bluff, I think, on it. Yeah. So we did have to put evidence before the court that an NOI will be filed if the plan's not sanctioned, and that happened an hour after the plan wasn't sanctioned.
But you've got a court saying, notwithstanding the previous dictas from people like Lord Justice Snowden, telling creditors who want to oppose the financial information how they ought to go about doing it. So get yourself in the arena, become a party, instruct your own expert, ask for disclosure if that's what you need from the company, and challenge whatever position the company are putting forward with your own position and let the court determine which is the more accurate. Both judges in these cases have pulled away from that and said that isn't what Lord Justice Snowden was saying, which is, I don't know how Lord Justice Snowden feels about that, but that's not what he was saying. He wasn't disputing that you can simply assess the evidence in its own right, and if you don't like it, you reject it. And I know in the Nasmyth decision, reading it, I mean, you guys were there, but reading it, it looks like the judge came perilously close to finding that administration wasn't the relevant alternative and that in somehow your company could have simply carried on and been funded.
Via an NOI, I think. He wanted us to put another plan forward and put NOIs down, even though there's no intention then to appoint an administrator, and propose another plan where the revenue got paid. But again, in the mid-market, that's another £400,000, £500,000 for the business, when the turnaround investor, our capital, had security anyway and could have gone the pre-pack route, which they did, and got the business back a week later. So it was that naivety or misunderstanding, I think, of how the mid-market operates and the costs that are available to these companies and the time pressures they operate under.
And also understanding what an NOI is. And the fact that the Court of Appeal have told us
we
can't just whack an NOI
yeah.
in and then try and do other things.
Yeah.
So, I mean, that's the bit that is interesting, let's put it as neutral as possible, about these decisions, that you have got a different approach from one judge to the next. but not just between these two judges. You've got what appears to be a different approach to expert evidence than previous judges had raised. And it does seem to me, picking up on Andrew's point, advising a client, how on earth do you advise them with any certainty that the court will accept the relevant alternative, or that somebody is no worse off, or that the plan works, if all that's going to happen is HMRC or any other disgruntled creditor is simply going to turn up and say, look, I'm not going to give you an alternative, I'm just going to attack bits and pieces of this and try and persuade the judge that they can't be satisfied on the balance of probabilities.
You probably have to pay HMRC in full over time, don't you? I think it may have been different if we were cramming down a secure creditor. I'm not sure the court would have been so sympathetic to a clearing bank if there was a cram down there. I think the fact that it was HMRC made it more difficult for us, and going forward we would have to put something forward for HMRC, payment in full over time, or a pot, I think, so they can share the restructuring surplus.
I mean, we were talking earlier on, it becomes difficult when, in our case, they were completely out of the money. So how do you justify paying them when
we couldn't really, could we?
The unsecured?
Yeah, that was more difficult.
Yeah.
But they're still useful tools, I think, to cram down secured creditors and other creditors. It's just the fact it's HMRC and the court's approach to HMRC and looking to preserve their preferential position, their special status. I think that made it more difficult than we thought it would, having looked at the previous case law. I think we felt the door was open there, following Houst, following Amicus, following Virgin Active, for the court to allow a sensible cram down of HMRC, particularly when they're out of the money, new monies were coming into the business. I think we felt we stood a reasonable chance, which is why the decision surprised us.
Well, I guess that leads to the question that really we're all here for, which is, are restructuring plans suitable for SMEs, especially when HMRC are involved?
The cost is difficult. You don't want to have a contested restructuring plans. You really want to tie HMRC up beforehand, I think, with a time to pay or a proposal that's acceptable. The fewer contested creditors, the better, because we had a 3-day sanction hearing and the cost was expensive. You want to try to do it consensually if you can. I think if it's contested, particularly if it's HMRC, I wouldn't want to go back to the court against HMRC again till they have a policy or until there was a proposal paying them in full. I think the cost and the time period makes it difficult. So we launched our plan in December and it was heard 4 or 5 months later. Yeah. That's quite difficult for a mid-market business. We needed the accounts filing, creditor pressure was piling up. It was a topco restructuring plan, but it was still difficult to hold that business together for 5 months. So they need to shorten the process, maybe do away with a convening hearing and just have a sanction hearing. It's got to be shorter and it's got to be cheaper, I think.
I think that there's a client management point as well that's always going to be hard with restructuring plans, and we were discussing it earlier. Mid-market, your documents are rarely as neat and ordered and chronological as you need, and getting directors to understand that. We had quite a few calls with the directors, and I'd sort of say, right, tin hats on, it's all coming at you, don't take it to heart. And that sort of openness and being not literally on a stand, but everyone looking at every act you've ever done for the last 6 years and calling it into question, that's quite tough. And especially when you're a small company and you have fought blood, sweat and tears to get that company to where it is. For that to then be crawled over with the benefit of hindsight is really a hard sell, when actually your alternative is quite often a pre-pack. No one really looks, is the reality. And so do you want a judgment where people are crawling through what you've done, or do you want to do a pre-pack and be done with it? And I think that sort of profile is definitely something that you can't quantify, but is considered.
Yeah, I mean, in our case, HMRC went to the extent of searching through our directors' personal tax returns and exhibiting them in witness statements, primarily on the basis that they said that was relevant to see whether the directors had any assets, if there were antecedent transactions brought against them, to see what the recoverability was like. But I agree with Hayley that small, medium-sized enterprises that are being put up in the public glare, and every step they've taken in the last 5-6 years is being poured through, and they're being criticised left, right and centre by HMRC and accused of wrongful trading and the like. And it's taking, as Steve said, 3-4 months, ours was a very similar timescale, December PSL, April hearing. It just isn't, on the face of it, the best way to go, unless, as you say, Steve, you can do a consensual restructuring plan, which means getting everybody on board in advance. or you're a regulated business and insolvency would terminate licenses or have a disastrous effect, then I can see why you might still follow that path. But hand on heart, if that wasn't the case and a company said restructuring plan or pre-pack, it is almost a no-brainer.
Or you're applying Leeds, looking at good box, and you could possibly get a restructuring plan more easily there. Swapping.
But
But it's a shame that you were going to revise for a pre-pack when the government were trying to encourage the debtor in possession route and as an alternative to Amsterdam and Chapter 11. It just feels a shame that it's being closed down. I'd still be interested in cramming down a lender, and I think the courts may be more receptive to that, with a new lender coming in ahead of the existing lender and the secure creditor getting crammed down. But you just need to be really careful about HMRC because it's difficult to predict, isn't it? You will get the right outcome, and the chances are you probably won't.
No,
I think.
Sorry,
I was going to say another thing that falls off the back of that lack of certainty is that as you're going through that 4 or 5 month period now, it's going to be more and more challenging to give the stakeholders of that business confidence. So we did a lot of work with the bank on that to make sure they were comfortable that the process was running through. There was some HP exposure in the subsidiaries. Again, we needed to take them through the process and buy them into kind of sticking with the business whilst they went through this process. And without the certainty that you can't now give, it's going to be more difficult to manage those stakeholders.
Yeah, I think that's right. I mean, if you'd asked me this time last year whether RPs would work for SMEs, I think my view would have been, and I'm sure I expressed it in various seminars last year, that but for the cost of doing it, then it seems to me they would work without any huge issues. And we had the backlog of very debtor-friendly decisions, didn't we, from judges, from restructuring plans of larger organisations, which made you feel like we were on a path. And
Amicus and House, all of those decisions were helpful as well, weren't they?
And then all of a sudden, House sort of rattles the cage of HMRC, not blaming you, Andrew, personally for that, but rattles their cage, and all of a sudden you've now got courts making what appear to be fundamentally different decisions on similar issues, such as expert evidence out of the money creditors, all those sorts of issues that we thought the previous decisions had helped clarify, and we're now back to complete uncertainty for SMEs with HMRC involved.
Well, Prezzo will be interesting, won't it, what happens on there? There isn't any new monies there, and I think HMRC are being crammed down on what the court decides there. Fitness First has shown a possible route forward by paying HMRC in full over a 5-month period. But I think Prezzo will be quite interesting to see if the courts row back again or follow that line from Leach and Johnson.
Yeah.
And HMRC's stance in Fitness First is interesting because they actively voted in favour. But when you're looking, it's one VAT liability payment that's only just arisen. You can see that I'll sort of wave that around and like, we voted in favour. We're not anti every plan. So I think when there is a substantial historic debt, it will be interesting to see.
We need a policy, don't we, from them, or some guidance from HMRC as to what's acceptable and what you need to put before them to get it approved.
Yeah, and even if it's, you can pay it over time, but the limit is 12 months, 18 months, I don't know what it would be, but at least have some target to aim at, because at the moment, these two decisions do make me think we're shooting at a moving target, not just because HMRC haven't got a clear policy, which doesn't help, but actually judges appear to be taking slightly different views on different things. So you could get a situation where, depending on who your judge is, depends on whether a particular plan gets through or a particular plan doesn't.
And we're going to get a wider range of judges, aren't we? It's not just going to be Trower and Zaccaroli any longer, is it? It is moving across to non-insolvency judges.
That's right. So when these first came in, they were the preserve of essentially Mr. Justice Trower, Mr. Justice Zaccaroli, Lord Justice Snowden when he was still at the High Court bench, and Sir Alistair Norris, who came out of retirement to do a few of them. But they were always wanting to expand it, and they have started doing that. So you will now get more in front of judges who are brilliantly able chancery judges, but don't necessarily have a background in insolvency. And I wonder if that makes a difference. I've got a sneaky suspicion that it does, actually, that on some of the issues we've discussed now, that to us as cynical, hardened insolvency practitioners, we don't see a huge issue with it, or we don't see it as being out of the norm. Whereas to a judge that simply hasn't had the exposure to this, perhaps understandably they do look bizarre or drastic, I think, as Leach described, the change in the critical creditor figure, and perhaps that's what we've got to deal with. But that just increases the level of uncertainty, because we're still in a relatively new jurisdiction, and we're now getting some bumps in the road, which doesn't make take-up of RPs particularly easy unless you've got certain circumstances.
I would just like to thank everyone for coming tonight and for all their views, and thank you for the engagement from the audience as well. And yeah, that concludes tonight.